There are few resources more precious than water. The public has an overwhelming interest in the management of this critical resource, and that interest is certainly more important in the beginning stages of a project than after the project has been finalized. For the public to be given information on water usage when the ink is dry on the deal is useless.
Google bought land in Botetourt County for a possible data center campus in June of this year. And since this announcement, there has been excitement, fear, and a lot of questions. Check out our previous video, but we left off when the Western Virginia Water Authority voted on 2 contracts with Google regarding how much water they'll provide.
I stood at one end of the courtroom, the executive director of the Water Authority and the Water Authority's attorney stood on the other. And for about an hour, we argued over this question of what is proprietary? Was this a proper use of the law?
A draft of these contracts seen by Cardinal News estimated starting with 2 million gallons per day, having the potential to increase to 8 million. But the public doesn't know if these are the same numbers that were passed in that vote.
After that board vote, I asked for copies of these contracts, and when I received them, information was redacted from them.
Google, they've maintained that that information is proprietary because with that information you could back calculate and figure out what size data center they want to build. They think that puts them at a competitive disadvantage with their customers. So they've asked for that information to be redacted.
Google and data centers all over the country cite proprietary information for this very reason. But Henri disagrees with this use, so he petitioned the Roanoke City Circuit Court and wrote about why in his publication, the Roanoke Rambler. But this dispute is not one of a kind. Legislation is being introduced to require data centers to report their water usage and have been shot down in states like California, New Jersey, and Virginia.
So the contract with all the attachments and various pieces is about 97 pages. The actual redactions in that document are about 20 words. So I would push back against people who've said we haven't been transparent.
It just so happens that the purpose of those contracts is what is being redacted.
The question right now is not, are data centers good or bad? It's, do you have a right to this information? Judge Lisa Ciafone says yes.
There are few resources more precious than water. The public has an overwhelming interest in the management of this critical resource, and that interest is certainly more important in the beginning stages of a project than after the project has been finalized. For the public to be given information on water usage when the ink is dry on the deal is useless. Citizens who cannot get information on the facts cannot weigh the costs and benefits in order to meaningfully participate.
Our meetings, we're a political subdivision of the Commonwealth. Our meetings are open to the public. People can come and express their concerns, and that's fine. We're totally happy with that.
Give us, the people you represent, the information we need to decide for ourselves if this is in our best interests.
But I think people want answers right now to questions that we don't necessarily know yet because we're still in the development phase. We're still trying to figure these things out.
Now, even though the judge ruled in the Rambler's favor, the Water Authority indicated they were considering appealing the decision. They have until December 22nd to file. This being a newer topic of conversation, there's a lack of legal precedent, so cases like this have the potential to set the tone for future data centers. Hi, thanks for watching. Make sure to like and subscribe.